Good day everyone, I'm Romeo Rosima, taking a course of Bachelor of Science in Tourism Management and STI College of Caloocan.
And I am Christine Ayos.
For today's lesson, we will discuss the negligence and the damages involving tourism and hospitality.
Under the course of Legal Aspect in Tourism and Hospitality.
So what are the objectives of this lesson? First is equip you as a tourism and hospitality student with the necessary knowledge of the law about torts and damages that you may deal with when you are already in the practice of their professions pertinent to the industries in tourism and hospitality. Next is inculcate in your minds the necessity to give you best effort in all the things that they need to do as serve the customers with utmost care and due diligence based on the every circumstance of each case.
So, what is the concept of tort? Well, according to Black Laws of Dictionary, tort law is a legal wrong committed upon person or property of independent of the contract. It is taken from the word tort, meaning to twist. So, according to our Article 2176 of the Civil Code, it is defined as a fault or negligence of a person who, by his act or omission, connected or unconnected with, but independent from any contractual relation, causes damage to other person. So, basically, it's wrongdoing or damage to another person or property.
So what are the major purposes of tort law? Here's the four major purposes of tort law. First is to provide a peaceful means for the adjusting the rights of parties who might otherwise take the law into their own hands. Second is deter wrongful conduct. Third is encourage socially responsible behavior. And lastly, fourth is restore the injured parties to their original condition, and so far as the law can do this by compensating them for their injury. According to this four, to summarize it, it is your responsibility once somebody has do you damage or you did damage to somebody. It is, as you see, for the second purpose, it is to deter wrongful conduct and provide the peaceful means of the settling a wrongdoing.
Okay, what are the elements of tort or quasi-delict? They have four elements. First is damages suffered by the plaintiff. Second is fault or negligence of the defendant. Third is causal connection between the fault or negligence of the defendant's act and the damages incurred by the plaintiff. And lastly, fourth, no pre-existing contractual relation between the parties. However, the Supreme Court held that even if there is contractual relation, nevertheless, the act that break that the contract may be also tort. To summarize these four elements, so damages suffered by the plaintiff, so there should be a fault by somebody and the defendant can be a person or it can be an establishment. Now, there should be a causal connection, meaning there is a cause and effect because of these things that they did or you committed. Somebody was deliberately you did. You deliberately damage something and then there is no pre-existing, as you see in fourth element. It says no pre-existing contractual relation between the parties. For example, you're on your internship or OJT sometimes. The employer would say there in your contract that there is no employee. Employer relation meaning if something happened to you inside the workplace while you're doing your intern, they are not liable. So if you sign something like that, therefore, number 4 elements will be in effect, no pre-existing contractual relation, but in that case, there was a contract for the relation, the two of you.
So here we define fault and negligence. Well, fault basically is an emission causing damages, while negligence is like not doing something, therefore causing damages. For example, somebody in the guest room slipped in the hotel and then causing for them to have a broken leg. Therefore, it is a negligence of the part of the hotel or not doing safety measure or cleaning the floors properly. So that's negligence.
Now, we have two kinds of fault. First is culpa aquiliana or culpa extracontractual. According to NCC, Article 2176, it is provided as a source of obligation, a substantive and independent fault in that there is no pre-existing relation. It is a separate source of obligation, independent of contract. For example, if I ride the jeepney, there's no contract between us. But because of negligence, for example, I bump into somebody causing the passengers to have damage or causing the passenger to panic. Then, therefore, this is the one that the kind of fault that this applicable to alignment contract and contract relation between us, but I still have an obligation to them. The second fault is culpa contractual or contractual fault. According to Article 1170-73, this fault exists as incident in the performance of an existing obligation. For example, when you sign your employee contracts, even if you're contracted inside an establishment or inside the company, they're required to take care of you if something happens to you.
Okay, according to Article 101 of the Revised Penal Code, liability of innkeepers and hotel keepers, it is provides that innkeepers and tavern keepers and any other persons or corporations shall be liable for crimes committed in their establishment. In all cases where violations of municipal ordinance or some general or special police regulations shall be or shall have been committed by them or their employees in default of the persons criminally liable. So meaning if some crimes happens within your establishment or damage happened inside your establishment, it is within your jurisdiction, but therefore is your responsibility. For example, there was a thief that happened inside your establishment. It is the management of the hotel's responsibility. So as you can see, here in restitutions of goods taken by the robbery or thief within their houses from the guests loading therein, it is the responsibility if a robbery happened inside the hotel.
Okay, that's all. Thank you. I hope you have learned from us.